fully on you. You have no choice when it comes to an exemption notification under Section 5A of the Central Excise Act. But such similar provision is not found in service tax. And therefore, in service tax as of today, exemption notifications are optional. You can choose it, you can leave it. But if you choose it, you have no option but to follow it. You see that decision in the GD Builders case, Delhi High Court, decision 32 STR. GD Builders case, where they say if you choose erection, commission, installation, entry, and the notification is there from, you have to follow it. Then don't come back and say 67% is not adequate, or I will not follow this, or no. You have chosen it, kindly follow it. In service tax, notifications are optional. You can choose to follow it, you can choose not to follow it. So my answer to 3 is Sterlite Industries will arrest her.
Just one question on this. We were debating this particular issue on another study circle as to whether the exemption notification should be considered as a mandatory thing or an optional thing. So one thought which was coming was that these exemption notifications are issued in under section 93, which can be issued only in the public interest. So when the question comes as to what is public interest, especially in the view of in the light of the indirect tax provisions, it says that the indirect tax is a destination-based tax, and that's why it is the ultimate consumer who suffers the incidence of this particular tax. So when it is a public interest and the government wants a particular service to be exempted in public interest, one needs to see that the incidence of that should not be passed on to the final customer. So whenever there is an exemption notification, one needs to mandatorily follow it in order to ensure that the incidence is not passed on to the final consumer. So what would be your argument on that particular aspect?
My argument on this is this. There is no impediment in taxation. If you want to make anything absolute, please say so. You have said so in 5A of the Excise Act. What stops you from saying so in 93? Even in 5A, notifications are issued in public interest. But what is issued by the government in public interest, absolutely are subject to conditions. The person who actually opts for it, the person who actually has to pay the tax, is given an option whether you want to go or you don't want to go with it, because I will tell you why. The reason is, if he goes for an exemption, he is not entitled to select credit, or he is entitled to proportionate credit. Now I can opt for paying my tax fully and taking full select credit. I can opt for it. And the best mechanism for reducing prices is competition, not your forcing an exemption notification or something. Let me also tell you why they forced excise exemption on to make it absolute so that people will follow it. It is only because they wanted reversals of select credit, not that they had to issue it in public interest. Let's be clear on that. That's the other thing. One more thing which probably you should think of is, you have to revisit whether this service tax is a destination-based consumption tax or not. Is it so? Where is it said so? Where is it said? I am sorry to say that the All India Tax Practitioners Federation decision in 7 STR, Supreme Court, which says the service tax is a destination-based consumption tax, is not borne out by the provisions of law. It seems to be a patent-based law. I am sorry to say this, because it is not borne out by, what does it say? 64(1), what does it say? Taxable service provided. When you come to the 66B, taxable service provided or agreed to be provided. Can, if it were to be a destination-based consumption tax, can a person who provides services say that the consumer is refusing to pay the tax, I will not pay? Can you take that stance? If it was a destination-based consumption tax, as is what is being told after the Supreme Court decision, as they say, that is an economic concept. I'm not saying no. It's an economic concept. If that was the case, then you should say that if the consumer refuses to pay the tax, the person who produces the goods or renders the service should be out of the tax net. Go and recover it from the consumer. I have a slightly different view on this destination-based consumption tax. I found it a preposterous observation. I don't lend any credence to it, because if that was the case, even some of the Delhi High Court decisions which say the P.L.V. Lal Bhavan's case, for example, which is in 40 BST, which says if the tax can be passed on and therefore should be recovered from the tenant. That is a contractual obligation. That has nothing to do with the service tax legislation. I think that is a totally wrong observation. You don't, that is a matter of civil dispute. It is not a tax dispute. Tax law is clear. The person who provides the service has to pay the tax. You can pass it on, you cannot pass it on. Whether it's very difficult to pass it on, that is your headache. That is my view. Yes, sir.
So you just stated.
No.
You just stated that section 93 is exemptions in service tax in absence of provision like 5A in service tax. These are all optional. Then the certain notification like threshold exemption notification specifically provide it's optional. Then where is the need to provide that it is optional?
See, just because a delegated legislation says something is optional does not mean the parent is not optional. There are any number of other notifications which does not say it is optional. Why they are saying it is optional is because if you exercise the option, you have to follow some procedures, that's all. If you exercise this option, you file a declaration and say I am following this for the rest of the financial year, don't reveal out of it. That is why that is condition. That is why they say it is option. So it is to put some procedural conditions that they say it is option. But it's a good question which you ask. Let's look at the fourth question. In the fourth question, all of you were unanimous that the credit should lapse and there will be no question of carrying forward the credit by virtue of notification 33/2012. What does 33/2012 say? And before we come to that, I would have liked you all to notice the provisions of Rule 11 of the semi-credit rules. Please look into it. Please take Rule 11 of the semi-credit rules. None of us normally touch this. It is like a very rare provision which is touched. That is the reason why I just gave this, this is one of the compelling issues which, if you look at Rule 11, subclause 4 of the semi-credit rules, what does it say? To my memory, it says, a provider of output services. You look at it very clearly. The provider of output service shall be required to pay an amount equivalent to the semi-credit if any taken by him in respect of inputs received for providing the said service and lying in stock. Stop there. Almost the same thing is said in 33/2005. The question here, if you see, is that they have availed credit on input services, not on inputs. The question that will actually you should have asked yourself is this: if I have availed credit on input services, can it be said that it will lapse by virtue of 11(4) or 33/2005? What does this 11(4) say? After deducting the said amount from the balance of sterling credit, if any lying to in his credit, the balance, if any, is still remaining shall lapse. No, does this balance refer to input credit or total sterling credit? That is the question. That is exactly the question which was asked. I have taken input service credit first of all. So nothing is going to be reversed. There are two aspects to 11 bracket 4. One is reversal of the amount, balance will lapse. Have you understood what I am saying? One is reversal of the amount. To the extent it is lying in stock, a reverse. The balance will lapse. Now, as far as reversal is concerned, I am not required to do the reversal because I have not taken input credit at all. I have only taken input services credit. As far as lapsing is concerned, can it be said the entire amount will lapse, or is it only in relation to the input? That is the question. Now, if you look, this is a difficult question. It has to be tested in the court. Let me tell you. It has to be tested in the court. If you look at the decision of the Supreme Court in Eicher Motors, 106-83. Eicher Motors, what did they say? If a credit is availed, it is a right which accrues to you. Eicher Motors, 106-80, page 3. It's a credit which accrues to you. When the credit accrues to you, you cannot be disentitled to the credit after that. It becomes a right which accrues to you. There has to be a specific provision in law which takes away the credit. It is because of that they brought into effect 11 bracket 1, 11 bracket 2, 11 bracket 3. The Eicher Motors decision actually led to the introduction of Rule 11. They had a similar provision in 57F4 of the rules then. 57F4. That led to this 11 bracket 2, 3, 4 where they disentitled credit for to be carried forward. So in this question, whether the credit can be carried forward for subsequent set-off, my view, it can be done. All that is reverse, asking for a reversal of a credit on input side is perfect. Asking for a lapse of the entire credit, which has been validly earned and set off in the earlier years, cannot be done by virtue of the decision of the Supreme Court in Eicher Motors. They should have specifically said of the entire credit, including input, capital goods and services credit. So that is my view. This view will be contestable. The fifth question, as I told you in the introduction itself, the Senate credit rules have been recast with effect from 1/4/2011, restricting the credit to certain sectors. Now, if you look at this, three heads are there: renting of cabs for transporting employees. This is one of the most, I may use the word, stupidest amendments that have been made by some babu sitting in Delhi. I cannot imagine anybody working in the BPO or the IT industry today, or for that matter any factory, not having to use renting facility. They have to do it, it's a necessity. It is not even an activity relating to business, which was there earlier. It is a necessity. Nevertheless, the stupid provision is there because there is an exclusion to input services. The only issue which comes here is this. If I am the person who renders the service and it is a capital goods for me, the capital goods What do you mean by capital goods? You look at Rule 2, it says that it should be registered in the name of the service provider. If I am rendering rental services of taxis, if that particular vehicle is registered in my name, then that is an eligible capital goods. I can take credit. Actually, this was very well analyzed by one of the groups when I was there. Very well analyzed. Where they tried to read these two provisions, which were disparate. Now, this, in fact, when this question was framed and we had an argument in office over this. If you look at this definition of input services, what does it say? Service provided by way of renting of a motor vehicle, insofar as they relate to a motor vehicle which is not a capital goods. Now the question is, which is not a capital goods for whom? Service provider or service receiver? Input, when I am talking of input services, when I am wanting to take the credit, let me say that I am the manufacturer and you are providing rental services. Right? Now, I am taking the same as an employer, I am asking him to use that car services. The thing is, the service is being provided by you. Insofar as they relate to a motor vehicle which is not a capital goods. It's a capital goods for you, not for me. If it's not a capital goods for me, I can't take the credit. Even other services, because the input services and capital goods were aligned in 2011. If you can't take credit here, you can't take credit there. That was the theoretical way it was taken. Now let's come to a situation where I recover some money from him. Can it be said that I am rendering the service? Can it be said that I am rendering the service? Can it be said that I am rendering the service? Yes. The definition of service, employee to employer, is out of the definition of service. Employer to employee is not out of the definition of service. So can it be said I am rendering a service to him and therefore recovering an amount? Even assuming that so, because in this example I would have probably said I paid service tax. Yes, service tax is paid on such collections. Assuming so, can it be then said, even if it is not capital goods in my, it is not registered in my name, I am providing the services of renting a cab. In turn, somebody else is providing the services of renting a cab. I am not taking capital goods credit. I am only taking input services credit. And because you have not specified in whose hands this should be owner, I can jolly well take the credit if I am recovering tax from somebody else. This is one view. I subscribe to this view. This is one view and I subscribe to that view. If there is no recovery being made, then I am on sticky wicket because absolutely the service is being rendered by you too, effectively. Here also, of course, this will be subjected to litigation, and let me tell you, I should also tell you the chances of winning this litigation is less than 10%. Let me frankly tell you, going by the current crop of what is going on, this is such a long-winded argument that I should do that nobody will have the patience to listen to me except this crowd which is sitting here. The higher the courts you go, the lesser is the latitude to give intellectual arguments. So as far as renting a car, renting of cars is concerned, you don't stand a very good chance to get the credit as the rules are being framed as of now. Let's look at security services meant for the residential colony. No, there are some very interesting arguments which are taken in all the groups, I must say. Security services is already listed as an input service. If you see the definition of input services, what is the change between prior to 2011 and after 2011? What is the change? Prior to 2011, it was very wide. It included activities relating to business. Any activity relating to business was included in input services. But after 2011, it has become a means and includes definition and excludes. Exhaustive definition. With some exclusions. That is how I would say. Security services, however, finds mention over there. One of the, I think there was a Gujarat High Court decision and a Bombay High Court decision in Manikarp Cement's case, where they said that these are welfare activities. No, where is it said in semi-credit rules that welfare activities you cannot take credit? Nowhere it is said. I am unable to understand the reasoning of some of our high courts in this country. They say only a factory above 250 canteen services you will be given credit. Where does it say below 250 you cannot take credit? Where does it say that? Where is it said that if something is not complied with the statute, it is not an exigency for you? Nowhere it is said. It's absolutely wrong. I'm sorry to say this, but it's absolutely wrong, this decision. On the contrary, I heard somebody mentioning this ITC's case. You take Andhra Pradesh High Court, ITC's case, 32 SCR. The Andhra Pradesh High Court clearly said that it was a business exigency, effectively. Security services meant for the residential colony. It is the first argument that we should, and some of you happily took it. Now, whose colony is it? Is it the employee's colony or is it my colony? It is in my balance sheet. Come on. Not only the security, yeah, insurance, that also should be eligible for credit. On the simple ground that it is a business asset. And I have the necessity to protect that business asset. On that grounds itself, credit should be given. So in my view, it falls under the inclusive clause itself. There is no need to go to the exclusion clause at all. Because there is no, it is not meant primarily for the consumption of any employee. No. It is meant primarily for my own consumption. Whether the MD requires security or he does not require security is a decision to be taken by the company. One of the things which was being discussed about the MD having to take security and other things. It is a business necessity for me. If I want the MD, if I don't want the MD, I want to give him security. Simple as that. If you have given him security, it's a business exigency. So whether it is recovered, not recovered, whatever it is, security services are eligible for credit in my view. Food facilities provided to the person. Now, typically this means that an outdoor caterer will come, cater over there and give his bill. Here also, is it, the question is whether it is meant primarily for the consumption of an employee or because my factory is located in a remote area, it is a necessity for me to give him, otherwise I can't retain that employee. I was giving an example yesterday, this is prior to 2011 of course, to some of my friends. guest house facility is being maintained by a company. We had a matter before the commissioner appeal, so when I went to the commissioner appeal, I told him please bring a superintendent. And he said, why? I said, no, please bring. He came, so I asked just one question. When you go to that cement factory from Hyderabad to somewhere, where do you stay? He said in your company's guest house. If you find it expedient to stay in the company's guest house, what about the others? And so maintenance of company's guest house, why would I? See, one thing I can't understand is this. Why would anybody incur an expenditure if it were not necessary? And who is to test whether this is necessary or not? These are two questions we should ask, or any court should ask. If I am incurring an expenditure, what is the necessity? Who is to judge the necessity? Is it the taxpayer or is it the tax administrator?
Payer.
We all say payer. Some IAS man says it's me. I decide who will give the credit or take the I am the data. It's very unfortunate. This is cannot read. I'm telling you, I think I will die fighting cannot read.
We want you to live long.
No, at this rate, no. After this negative list came, I'm telling you, I'm really telling you, I do not know. Every seminar, every lecture is a learning experience for me. The questions that are asked by our friend from Nashik, for example, beautiful questions he asked. Development right, actually what he asked, transfer of development right. When one developer is already having the rights to with the landlord, he admits another man. It is nothing but transfer of development right. Now, is transfer of development right subjected to service tax? That is the question. That should have been the question you should have asked. When I cede away my 100% rights to another developer, and then we do it jointly, and therefore you collect a premium from him, is it transfer of development rights? That is the question you should have asked. I don't know if that is what you meant. No, I'm just telling you, so interesting is that I don't want to enter into issues. That would be wrong for me to do so. Transfer of development rights. So that is subjected to service tax. See, why I'm telling you is that I am quicksand. The topic itself is so complicated. Because by passing a reference, I will tell you, there is a decision of the Bombay High Court in Chajjad housing. CHAJED, Chajjad housing. This is in how you pronounce it is for you people to correct. Because I don't know your. Please excuse me for the pronunciation. I come from South. This is in the context of the specific relief act. With your permission, I will just answer it. The issue was, in development right, a person wanted to enforce it. Let us say you transfer the development right and then go back on it. Person wanted to enforce the development right, saying he has already entered into an agreement to cede the development right, it should be enforceable. Now, whether it is enforceable or damages is in